All right, so we started with the intro part and difference, plus we have few more things like history, application of the legislation, where is it that CPC is applicable. Then we have jurisdiction of Code of Civil Procedure. Okay, so that part previous part, it's clear, right?
Yes, yeah, it is clear.
All right. So when we talk about
and just one clarification, the difference between this schedule and sections, like if I want to explain to a layman, is there a way to easily understand between a schedule and like sections?
Yeah, so sections are nothing but the powers of the court. Okay, like it will tell you that, okay, fine, this is the jurisdiction, these are this is how court will exercise the matter, these are the things where civil court will have a jurisdiction. But what is the process? Okay, how is it that actually civil court is going to use that power? That process, method, or manner is provided in the schedule part. So schedule part is like more practical thing, but the sections which we have, it's like theoretically it is explaining or it is properly setting the jurisdiction of the courts, like that you can see. And when we start with the sections, right, it will become even more clear for you. Then you will be able to like understand the difference in a better way, because that time you will actually be reading the sections plus what is given in schedule, like the different orders. Okay, but for now, yeah, it is all about what powers are there, like a theoretical aspect. And when we talk about schedules, it's like how is it that really courts are going to use that power or use that jurisdiction rather.
Okay.
All right, so one more part we have is like the history of Code of Civil Procedure. As such, I have not seen questions being framed from this part, that what was the history, write something on history as such. But yeah, it is like a small topic where we need to know what legislations were there before Code of Civil Procedure came into force. Okay, so before 1858, we were not having any set process for the civil suits. Okay, how civil suits will be settled or resolved, we were not having like a uniform rule for that. It was different for all the different parts. So to give uniformity to civil procedure, so that when a person is filing a case, when there is a civil suit, civil dispute taking place, the party will have some sort of understanding on how the case will go on. Like today, if we are filing a civil suit, we know how much of time it would probably take. We know what will be the different stages of that case. So that is possible only when we have uniformity of the procedure, and that uniformity will be set through some legislation or through some rules of process. So it was in order to give uniformity of civil procedure, Legislative Council of India enacted. The first one was called as Code of Civil Procedure 1858. Okay, so this Code of Civil Procedure 1858 was introduced, and then, like we know today, President needs to give his assent. Same ways, it also took some while for Governor General to provide his assent, and it was on 23rd of March 1859, a year later, that assent was given, and this law came into like full force. But then what was the problem with it is that it was not applicable to the Supreme Court in presidency towns and to the presidency small causes court. Even though legislation was established, even though legislation was framed, it was not uniformly applicable in entire India. That again was creating confusion because different process will be followed, different rules will be there. So it was not serving the purpose, because main purpose was uniformity, bringing uniformity in how a civil suit will be resolved, and that part was not being done. This code, however, was not applicable, so it was not serving its purpose. it did not meet the challenges and was replaced by the Code of Civil Procedure 1877. Few years later, a new legislation was introduced because the previous one was not serving its purpose. But still, it did not fulfill the requirements of time, and large amendments were introduced. A lot of amendments were introduced even then it was not serving the purpose. So again, in 1882, another legislation was introduced. It also was having its own defects or demerits. And finally, to like eradicate all of those shortcomings, all those problems that were there, we had Code of Civil Procedure 1908, which was enacted. Again, this legislation has also undergone a lot of changes in order to ensure that civil suits can be resolved quickly. It's not like for 10-15 years, people are just behind one simple case only. So in order to ensure speedy redressal of matters, a lot of changes were being introduced. Along with amendments in CPC, there are certain other steps also being taken. Like you would know, there is Motor Vehicles Act, right? For road traffic accident, people would file a case to ask for compensation. There, under that legislation, it said that civil courts are already overburdened with a lot of things. So let's introduce the tribunal there. For motor accident claims matters, let's introduce a tribunal, and that tribunal will have sole authority to decide on such matter. So in order to reduce burden of civil courts, a lot of other things are also being done, like setting up of tribunals, setting up of some special courts, referring some matters for mediation, arbitration, and stuff like that. So apart from making a lot of amendments and changes in Code of Civil Procedure 1908, other steps are also being taken. And with all of those taken together, Code of Civil Procedure, even though it's such an old legislation, it's still valid and it is still serving the purpose properly. Okay, so basically before that also we had a lot of legislations, and from that we learned what all things were not working out, and we got the chance to introduce this one. Like when you study about sources of law, you also get one point, right, where legislation is a source. Do you remember that from maybe jurisprudence or something?
Yes, ma'am. Yeah.
You remember, right? So this is a very good example. How is legislation? How is legislation a source? Because it is through one legislation which is applicable now, we realize the shortcomings in that and we can bring a new legislation. So this Code of Civil Procedure in itself is a very good example of that, that previously we had few legislations, they were not working out properly, then we had new legislations, and finally we have Code of Civil Procedure 1908. Okay, so this is just like a small part that you can read for your own understanding. As such, I haven't seen such questions in the exam. Okay.
Yeah, from 1908, it was enacted and came into existence also.
Yes.
Same year.
Yeah.
Okay.
Next, we have one more part. Came into forces 1st of January 1909. Okay, a year later. Just like, because it was 21st of March 1908 when it was introduced, so it took few months time. Okay, I think that date is also there somewhere at a later stage, but yeah, it was in March that it was introduced, 1908, and 1st of January 1909 it became applicable for all the matters which were there. And usually this time is given to make the arrangements which should be needed to make a law applicable, right? So might be certain officers needs to be appointed, some bodies need to be set up, certain processes need to be fixed, so a bit of time frame is given. All right. Next part is on scope of this legislation. So this code is exhaustive on matters specifically dealt with by it. However, it is not exhaustive on points not specifically dealt with therein. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigation, and consequently for providing procedure for them. With regard to those matters, the court has inherent power to act according to the principles of justice, equity, and good conscience. Now, when a law is introduced, take for example, today we want to introduce a law on certain matter. Might be there are like 10 very intellectual persons sitting there for drafting this legislation, but those 10 people can think about only limited situations, only about limited possibilities. And taking all of those things into consideration, they will frame a legislation. But in the years to come, there will be so many other situations, so many other types of disputes or other areas which may be highlighted before the court. Because humanly, it's not possible for us to think about all the possible outcomes or situations. So it says that this code of civil procedure, whatever best possible situations it could think of, all of those situations are taken into consideration. For that, law is being framed, and provisions of CPC are exhaustive. It includes everything, and that will be applied for those matters. But then it's not possible to think about all the given situations. So if there are certain situations, certain areas that CPC has left out, those areas will be, like how will court decide? Because court still needs to decide on such matters. So court will decide based on the principles of justice, equity, and good conscience, because law is not properly set there. So it's very clearly mentioned in Code of Civil Procedure itself. What is principle of justice, equity, and good conscience? Have you got it somewhere?
I'm not recollecting.
No, okay. So justice, equity, and good conscience basically means that otherwise we have written laws, we have legislations, we have different codes. So when a matter comes before court, court will look at the legislation, whatever provisions are there, court will try to apply it in the given situation. If there is a case of theft, case is being filed before the court, court will open IPC, court will see the ingredients. If the ingredients are present, court will say it is a case of theft, and punishment will be mentioned, given whatever is mentioned in IPC. But what about the situations wherein law is not yet properly set? In such cases, court applies principles of justice, equity, and good conscience, wherein judges will try to apply their mind, and judges will try to see what is the best possible thing that they can do. Okay, what will provide, what is just in this given case, so that neither of the parties are suffering, neither of the parties are losing out on their rights. Okay, based on equity, court would try to provide a decision so that both the parties are in, like it can be balanced in a certain way, we can say. Okay, so whenever CPC has not mentioned the process, CPC is silent on certain matters, those matters will be dealt with by the court through the principles of justice, equity, and good conscience. Court or the judges will try to apply their mind, whatever best they can do in that given situation, they will do that only. Okay.
Yeah, is it like restricted to only district courts have the power?
Actually,
or anything like that?
No.
From civil
No.
procedure?
See, CPC
Okay.
would be applicable even if there is like a civil appeal filed in the High Court or Supreme Court. It will be applicable, right? All the matters, same procedure will be applied. But this principle of justice, equity, and good conscience, it's not even only limited to civil laws. It is applicable in civil, criminal, in any kind of matters. Court can apply the principles of justice, equity, and good conscience, and court can give a decision based on that. It's not just limited to CPC. Like there was one case under Indian Contract Act, you will read it sometime. So what happened there, right? Otherwise, a minor is not entitled to enter into a contract, right? The person has to be a major person above 18 years. Plus, there is also one like provision under Indian Contract Act, which says that, take for example, today I'm saying something, okay, like I'm entering into a contract with you and I have made some promise. Tomorrow, I cannot say the opposite of it. All right, I will be restricted by court. Court will stop me from saying something opposite to what I had said yesterday. So yesterday, if I had promised that, okay, I will do this, today I cannot say that, no, I'm not doing it. Court will ask me to pay compensation, or court will ask me to perform that specific thing. All right. But in case of minor, that rule is not applicable, because minor is not entitled to enter into a contract itself. So if minor is saying something today, tomorrow they can say the complete opposite of it also. Law will not restrict them because they are not entitled to enter into a contract. So that is a set rule. But then in a certain case, right, what happened is there was a minor. He misrepresented himself to be a major person in front of another, and he said that I'm having this property, I'm a major person, I want to sell this property to you, okay, for the certain amount. And the other person also agreed. He paid half of the price of that property, okay, and he said this remaining half also I will pay. He signed on a paper. After taking this payment, minor said, I'm minor, I'm not bound to perform this contract, I'm not returning you the money, and also I'm not giving you possession of this property. That means minor tried to take advantage of this position, right, of this law which is there in Indian Contract Act. In that case, court applied the provisions of justice, equity, and good conscience. Court said that, okay, fine, under Indian Contract Act, law is already said that minor is not bound by the contract. Minor is not bound by the promises that he has made. But we cannot allow the minor to take unfair advantage of that situation. So what we can do is we will apply justice, equity, and good conscience. And court said that, yeah, minor is not bound by the contract. So you are not bound to give possession of the property, but for sure you are bound to return the payment. That is nothing but equity, justice, and good conscience. What is best possible thing that you can provide, that will be provided. That is what the concept is all about, okay? Now, where is this code applicable? Application of this code, because there has to be some jurisdiction where it applies. So what do you think is the territorial jurisdiction of Code of Civil Procedure? Where is it applicable?
Is it across India?
Across India, okay. Any exceptions? Because most of the legislations you will see, right, it applies in entire India except the state of Jammu and Kashmir. So what about Jammu and Kashmir?
I think Jammu and Kashmir is also included after the.
Okay. After?
Yeah, recent removal of Article 370.
Correct.
Not sure, but.
Correct, you are right. So, yeah. So Code of Civil Procedure, it is applicable in entire India, including the state of Jammu and Kashmir. But even then, if you look at the legislation, like a screen is visible, right? Different part.
Yes.
So even now, if you see, it extends to the whole of India except the state of Jammu and Kashmir. It still mentions except state of Jammu and Kashmir. And same happens for most of the other laws also. And that time we may get confused that is it applicable in Jammu and Kashmir or is it not? Okay. If you have that question anytime for any legislation, you can always open this legislation. Okay. It is called Jammu and Kashmir Reorganization Act. Okay. In this
Okay.
legislation, Jammu and Kashmir Reorganization Act, here what happens is there is one schedule, fifth schedule. Fifth schedule provides for list of central legislations in India, which were previously not applicable in Jammu and Kashmir, but now, after removal of the special status, these laws will be applied in Jammu and Kashmir. Okay, and there are around, I think, 106 laws, if I'm not wrong. Yeah, 106 laws. There are 106 laws parliament passed by parliament, which will now be made applicable in Jammu and Kashmir. Now, it's practically very difficult to amend every single law, right? Just one word we need to remove. For that, it's very difficult to amend all those 106 laws. So rather than doing all that stuff, what they have done is in this schedule itself, fifth schedule, they have clearly mentioned. Okay, if you look at the starting part, see name of the act, section or amendments. What has been amended in this legislation? Central laws made applicable to Union Territory of Jammu and Kashmir and Union Territory of Ladakh. That means all these laws are now applicable in Jammu and Kashmir. And this part which I told you, right, still it mentions Jammu and Kashmir. We should omit this part because it is written here. Okay, if you see.
Right.
See, Code of Civil Procedure, it will be mentioned. Yeah, Code of Civil Procedure, Clause A, subsection 3 of Section 1. So what is it? Section 1, subclause 3A, it has to be omitted. That means this state of Jammu and Kashmir is being omitted, and CPC is, as you said, correct, applicable in Jammu and Kashmir as well as Ladakh. But there are tribal areas like Nagaland and some other areas. Just like how special status was given to Jammu and Kashmir. Okay, Jammu and Kashmir special status was like at this level. Okay, they had special status for all the matters except for 3 defense and two other. Okay, everything else they had full control. But there are certain other tribal areas wherein constitution provides for some special status to them, not like as compared to Jammu and Kashmir, it's like very minimum. Okay, certain here and there some provisions are not applied. In some matters they are given a bit of liberty because tribal community needs some sort of like, they want to like preserve their culture and stuff like that. All right, so Nagaland is not governed by this regular courts. Okay, like we have IPC, we have CPC, they have their own customary laws which are applied there. Okay, for all the matters that will be followed. Like CRPC, if you compare, you can compare it with the customary laws of Nagaland. Okay, along with Nagaland, there are some other tribal areas where few here and there, few things will not be applicable. Apart from this, entire India, it is applicable. Code of Civil Procedure is applicable. Okay. That was about the application of this legislation, history of this legislation, scope of the act. Now, there is one more part which is jurisdiction of courts. Okay, so jurisdiction. As I said, certain words will be defined in the law itself. Okay, certain words will be defined just in order to avoid any sort of confusion. Like if I show you, usually in a certain legislation, it is section 2, which provides for definition of certain words. In most of the cases, it's section 2. Sometimes it may be given in other section as well. So this section also defines certain words like code, decree, decree holder, district, foreign judgment, foreign court, so many other things. But in all these things, see, judge also is being defined, judgment defined, judgment debtor defined. But then jurisdiction as a word has not been defined in the code. Okay, when we talk about definitions, it has not been defined. But in simple words, we mean it can be described as power of the court to settle the matter, whether court is having the authority or power to take up a certain matter and give a decision on it or not. That is nothing but, in simple words, what jurisdiction is. Now, whether court is having power to decide on a certain matter or not, it will be decided based on various factors. Okay, one is the territory of the place where the crime was committed, or where the wrong has taken place, like you said yesterday. What were the other grounds? Do you remember any other ground? Jurisdiction. Territory where the crime or the wrong has taken place, apart from that. It may be punishment or the relief which may be granted, right? Whether court is having power to give that much of punishment or that kind of a relief or not. And also it may be subject matter jurisdiction, whether court is having jurisdiction to decide on this area of law or not. Okay, so these are the grounds based on which it will be decided, and we would come to know whether the concerned court is having power to settle the matter or not. Now, this concept, okay, it has developed from this Latin maxim, ubi jus ibi remedium, which means when there is a right, there is a remedy. It is not enough that simply it is said that, okay, you have this right, you have all these rights, take it. No, it's not enough. Constitution is also providing for so many fundamental rights. There are other legislations also which are providing for bunch of other rights. But just mentioning that you have this right is not enough. There has to be a remedy as well. What if we are not able to enjoy our right? Where can we go? Whom should we approach? That is nothing but remedy. So this concept, ubi jus ebi remedium, it is very important concept which says if you are being given a right, like a legal right, law will also provide you some sort of a remedy. And in order to seek for that remedy, we would approach the court, and that is where court needs to have jurisdiction to entertain us, to take up that matter. So the judicial forum must have jurisdiction to deal with the matter, and hence jurisdiction commonly rests with the with where the crime is committed or where the wrong has taken place. Territorial jurisdiction is like the most common type that we discuss, but otherwise also there are different types of jurisdictions which are there. Now, there may be a certain case where court has taken up a matter where court was not having jurisdiction, lack of jurisdiction, and irregular exercise of jurisdiction. Court was not having jurisdiction, still it took up the matter. Court was not having jurisdiction, still it exercised jurisdiction in a wrong way. What will happen in such cases?
The judgment will become void.
Yes, judgment will become void because court is not having the right jurisdiction. Correct. So whenever the suit is made before the court, the initial issue is to decide whether court has jurisdiction to deal with the matter or not. If the court has all the three jurisdictions, then the court has power to decide the case. And if the court does not have any of the jurisdiction, then it will be recognized as lack of jurisdiction or irregular exercise of jurisdiction. Usually when a petition is filed, right, that time only they will mention that this is that, and you are the right court to take up this matter. That means it is already set up that this court is having the right jurisdiction to decide on the matter. And when the case is being filed, there also court will see if it is having right jurisdiction or not. If not, it will dismiss the case and it will advise that refer this case to so and so court, because that is the right court where jurisdiction is there. And like you said, yeah, if in a certain case court has exercised it by mistake or something has happened, court has given a certain decision, that decision becomes void. It is not binding.
Okay.
Now, how do we decide jurisdiction and what are the different types of jurisdictions? One, fiscal value, another one, geographical boundaries of a court, another one, subject matter jurisdiction. So we'll start with one by one. So territorial or local jurisdiction, you have already mentioned this, that geographical limits of the court's authority are clearly specified. It cannot exercise authority beyond the geographical area. So usually for all the courts, geographical location will be fixed, and within that area, if that certain wrong is taking place, the court will have territorial jurisdiction or local jurisdiction to take up the matter. So if a certain crime is committed, certain wrong has taken place in Madhya Pradesh, the court within the local boundaries of Madhya Pradesh will have the power or the right jurisdiction to take up this matter and decide on the case. Territorial or local jurisdiction, that like local court we should be approaching, sort of thing. Another one is pecuniary jurisdiction, which is related to the capital. It approaches the question whether the court is competent to try the case of the financial value. Like we have this Suit Valuation Act, right? So what is the value of that case? Is the concerned court where parties have approached having pecuniary jurisdiction to try a case of that much financial value or not? If the court is having that, court will be allowed. It will be a court having right jurisdiction. If not, that is not the right court to approach. Same ways, we have subject matter jurisdiction, which is like you would see, admiralty jurisdiction. So admiralty jurisdiction is like certain high courts are given this power wherein there are territorial waters, okay, where there are certain seas and that certain state is having access to it. Those high courts will be given the power or given subject matter jurisdiction on admiralty matters. Okay, all the high courts do not have admiralty jurisdiction. It is only those high courts which are having territorial water within their like area. Okay, only those are having this jurisdiction to try such kind of matters, because those matters will be arising in front of them only. Okay, like Bombay High Court is having, because Goa is there. All right, like that we have. This is nothing but subject matter jurisdiction, that this certain subject matter, admiralty jurisdiction, all high courts are not given. It is only some specific high courts which are given. Okay, same ways we can say, take for example this Motor Vehicles Act. Like I said, if you want to file a application for compensation and there is a motor accidents claim tribunal set up in your district, you cannot approach the regular civil court. You should be going to motor accidents claim tribunal only, because that tribunal is having subject matter jurisdiction. For that subject matter, it should go before that court only. Okay, like debt recovery tribunal we have. So for that, it has to go to that court. Like that, we have subject matter jurisdiction also. For this certain subject matter, it should go before this specific court only and not any random court. Okay. These three things clear, right?
Yes, yeah. We have this green tribunal which will deal with this environment related
National
concerns,
Green
right?
Tribunal.
That is also a subject matter.
Yeah, that also. They are doing very, like some good decisions also they have passed. So yeah, National Green Tribunal would also be one like that.
Okay. Okay, fine.
This Art of Living, in fact, was celebrating their some some year of celebration. Okay, they completed how many years? That celebration was going on near Ganga. So they like polluted this beach and other stuff. So the National Green Tribunal had asked them that you need to clean all the mess that you have created. Like that, there were, like it was few years back only, but yeah, good things that they are doing. Is that also subject matter? Correct.
Yeah, on the Yamuna backwaters.
Yes, correct. So another one we have is original and appellate jurisdiction. So what is original and appellate? Original as in first time you are going before that court. Okay, and appellate as in from somewhere else you have reached there. When we say appellate jurisdiction, it refers to court's authority to review, revision, or appeal related matters, that you were not happy with the decision given by lower court. That is why you have come to the higher courts. That is nothing but appellate jurisdiction, wherein court will entertain a matter, and it's not the first time that you are approaching the regular court. You have come from some subordinate courts before it. When we say original jurisdiction, it refers to court's authority to take notice of the case. As in, first place you are going before the court, that is original jurisdiction. So usually we would approach the lower courts, the subordinate courts for any kind of civil matters, right? We would approach the subordinate courts. But there are 3 high courts, okay? Bombay, Calcutta, as well as Madras High Court. These 3 high courts are having original jurisdiction to deal with any random matter. Like if there is a rent dispute, okay? If there is a tenant dispute, if there is a property dispute, for any sort of matter taking place in Bombay, Calcutta, and Madras, the parties are free. They can take a decision whether they want to approach the subordinate court or they want to directly approach the high court. Okay, because high court is also having original jurisdiction on such matters. That depends on the parties where they want to approach. That is like a very peculiar thing about these 3 high courts that you can remember. Okay, so original basically means for the first time you are approaching that court for your matter. Okay. Plus there may be like a lot of tribunals are being set up, right? So if you are not happy with decision of a certain tribunal, there also you can approach the high court. That also will be original jurisdiction, because you are not coming from the subordinate courts, but you are going directly to the high court from a tribunal. Like income tax matters, we can file it before income tax appellate tribunal. But when parties are not happy with the decision given by income tax appellate tribunal, they approach the high court of the concerned state, and that appeal is considered as original jurisdiction. Even though it's an appeal, it is still filed under original jurisdiction of the court. Because parties are directly coming, they are not coming from subordinate courts, from a tribunal, directly jumping in the high court. Okay, so this is what original and appellate jurisdiction is. It's clear, right?
Yeah.
Next one is exclusive and concurrent jurisdiction. Exclusive as in this court
how they are classified? Like initially we had 3 types, right? Based on the territory, subject matter, and is there any like at main level the classification, or
which one are
these
you
are all like different? We initially we had 3 types, no? Territorial, subject matter.
Yeah, actually,
and this is other kinds.
Yeah, these are the main like jurisdiction that we talk about, but these are like some other, okay, some additional thing you can say which are used. But when filing a case, right, usually those 3 are the main things that we consider. These are some additional classifications in order to understand powers and functions of court. Usually we refer this classification.
Okay. Main bases are those 3.
Yeah, main bases.
Other than these are the additional.
Yeah, these are additional. And if you want in that list only, you can mention those 3. After that, you can mention these as well. Okay, no harm in that also. Yeah. So original and appellate done. Next one is exclusive and concurrent jurisdiction. Exclusive as in exclusively that court is having jurisdiction. Like I said, motor accidents claim tribunal. If in a certain district, a motor accident claims tribunal is being set up, the legislation very clearly specifies that only this MACT will have exclusive jurisdiction to try motor accident claim cases. Parties cannot go to regular civil courts to file the matter because civil courts are already burdened with a lot of other things. Plus, MACT is like a specialized body. They are only dealing with motor accident matters, so we should be approaching that because it is having exclusive jurisdiction to try matters related to motor accident claims. Okay, that is exclusive jurisdiction. What is concurrent jurisdiction? It means where two or more courts from different systems simultaneously have jurisdiction on a particular case. So there are two or more cases at the same time, they will have jurisdiction. It's not like first you go to the lower court. If you are not happy, you can appeal in the high court. Not like that. At the same time, two courts at different levels are having jurisdiction. That is concurrent jurisdiction. Like we have concurrent list, right? State list, central list, and concurrent list. Both center and state can pass laws on that. Same ways here also, it is concurrent jurisdiction. Two courts from different levels are having jurisdiction at the same time. Like I said, Bombay High Court. Bombay High Court and a subordinate court in Bombay, right? They will be having concurrent jurisdiction to take up a certain civil matter, because that is like a peculiar thing about Bombay High Court, Calcutta High Court, and Madras High Court. Okay, so concurrent as in two courts from two different levels at the same time having jurisdiction. Parties can take a decision which court they want to approach. This is clear, right?
Yes, yes. Can we relate this KSLU case? Students had filed a petition both in Dharwad and Bangalore bench.
Yeah, two correct. Both are going on. Yes, you can mention that.
Right.
Right. Both are pending, right? Or one was disposed like December.
Dharwad bench, they gave for even semester, 3 years course. And yeah, based on that, our exams got cancelled.
Okay.
But for the 5-year, Bangalore bench gave a decision that to hold the exam.
Bangalore bench held that, conduct the exam?
Yes, yeah, conduct the exam. It was actually already going on. By the time they gave the verdict, it was almost the end of the exam.
Okay.
And university claimed that 70% of the students had already attended the exam. And that was also considered while giving the judgment.
What about the remaining ones who were like, might be expecting the judgment?
Yeah, they are waiting for some decision from the university side itself.
Okay.
Because most of them were like outside students, it seems, out of state students.
Okay.
And they were in confusion whether to attend or not, and they were most of them were absent.
Okay.
But
so
looks like
repeaters exams got cancelled, and the regular ones
no, repeaters was done. It happened without any disturbance.
Okay.
But for the freshers only, they had filed saying that online classes were not done properly, and rural area students didn't have the like chance to attend classes and all. Based on that, they had filed the petition. And Dharwad bench said that yes, you can promote for 3-year students, because petitioners were 3-year students.
Okay. So will they get like promotion just like that, or how is it?
As of now, university has said the same. But there is a rule in BCI, it seems, that without examination, course will not be valid.
Okay.
That's what, like, not sure what they will do, but as of now, they have asked to start the next year classes and all.
Okay. What about you? Your previous semester exams over or it got cancelled?
Yes, yes. No,
Over.
Arrears exam got done. Yeah,
Okay.
not for fourth sem.
Too
Fourth
much of
sem
confusion.
didn't happen.
Correct.
Yes,
And
ma'am.
so much, like too much of confusion, right? And so much of
Right, right, right.
test
Yeah.
and everything. And like students also will be like, okay, fine, might be no exam. They would not study and suddenly
Right, right. Yeah,
notification.
same thing happened. Yeah, in October it was said like we have exam. Later postponed to November and finally December, and it also got cancelled.
People will forget whatever
The
they
one thing
learned.
is, yeah, regular students it's okay, but we study mainly for exam purpose,
Mm-hmm.
and we will lose the like subject.
Right.
Yeah.
Okay. So one more is their general and special jurisdiction. General
Mm-hmm.
jurisdiction is that general courts do not limit themselves to hearing only one type of cases, like the regular courts which we have, like a city civil court. Okay, they should not limit
Mm-hmm.
themselves to hearing only one type of case just because other tribunals or other special courts are hearing cases on specific things. They should not limit themselves to one type of case only. This type of
Mm-hmm.
jurisdiction means that court has power to hear all type of cases. So the court has general
Mm-hmm.
jurisdiction to hear. If it is like a criminal court, it will have jurisdiction to hear all the criminal cases, unless and until it is like specifically mentioned that only this court it should go, like check bounce, it should go before a magistrate court only. Unless and until something like that is specified, they should be like open for all the matters. Same goes for civil court, family court, and other like the regular courts. They should be open for different types of cases. But when we talk about specific jurisdiction, it is the ability of the court to hear lawsuit in a state other than defendant's home state if the defendant has minimum contact. So specific jurisdiction as in for some specific matters only, they would be taking up the case. It is not like they will be open for any sort of civil matters, any sort of criminal matters, but only one specific type of or area of law will be assigned to them, and only for that they will be like taking that up, and they will have a jurisdiction to decide on that particular case.
Mm-hmm. Is any example for this, for general?
General one, like if there is a city civil court, it will
Mm-hmm.
even take up a matter like, take for example, there is some mistake in your birth certificate and you want to correct it.
Mm-hmm.
It got delayed for a very long time. There, you cannot just directly correct it, you need court's order. So, there you will file a case in the court asking for court's order. So, that court will order the concerned bodies that you make the correction in this birth certificate of so and so person. That is one matter. If there is a trust that you have set up, you want to make certain changes in terms of the trust, there also you will approach the same court. If there is a landlord tenant dispute, you are approaching the same court. If there is a property related matter, succession, probate, these are all like unrelated matters, right? But still you are approaching the same court. That means court is open to hear most of the civil suits that may take place. Same ways a criminal court also will be open for most of the criminal cases that may take place. These are like the regular courts, so they will have like a general jurisdiction. All these matters would be filed before them, because for every single matter it's not practically possible that we would have like a separate court, right? So that is the reason why it's there. Then we also have one provision inside CPC, this section we have, that part we will discuss when we start with it. Okay, application jurisdiction. Okay, so we basically need to start with the legislation, and there again you will get this jurisdiction as mentioned under CPC. Okay, so you can go through this part for now, and this thing we will continue maybe Wednesday. We will have a class. Okay.